let's go on so we're on YouTube. This is on DC 21-10024. Parties have agreed that if we need a record on this case, that the court reporter, an official court reporter, can go ahead and transcribe directly from YouTube. Is that agreed to, Mr. Goolsbee?
Yes, Your Honor.
And opposing counsel?
Yes, Your Honor.
All right, go ahead and state your names for the record.
Your Honor, Edward Goolsbee on behalf of the plaintiffs, along with my co-counsel, Kyle Pelker, and Timothy Seib himself is also on the call.
Daniel Triano on behalf of each of the defendants, beginning with Seib Holdings LLC et al.
Let's proceed.
Your Honor, we filed a motion to compel on behalf of the defendants, requesting that we be permitted to create a mirror image of a cell phone that is used in the possession of Tim Seib, who appears to be on the Zoom call today. The long story short is, on April 19th, we served a request for production of that cell phone at a date and time certain at the office of a computer forensic examiner, requesting that the cell phone be presented at that time to be imaged. We received objections, and the cell phone was not produced at that time. I know Scott Shanes, my co-counsel, was in communication with Mr. Goolsbee for over the last month or so about that. I know there were discussions about sort of limiting the scope and narrowing the procedure, narrowing the protocol, and that sort of thing. It wasn't just simply, provide the cell phone and we get to see everything, every text you've ever sent, every email you've ever sent, every call you've ever made. There were discussions on narrowing it in that way. Those discussions were not productive, and that's why we're here. Under Rule 196.4, a party is required to produce for inspection a tangible thing that's within its possession, custody, or control. Requests for electronic discovery are governed by a Texas Supreme Court case, In Re Weekly, which is discussed at length in the response. It's our position that we satisfied the requirements of In Re Weekly to be able to permit that inspection. I'll just sort of quickly run through that. The lawsuit, just in general terms, was filed by Tim Seib and his entities, alleging that Tim Seib was wrongfully terminated, or at least that's sort of one of the underlying allegations, that the basis for his termination, or whether he was terminated at all, was improper. We filed counterclaims alleging that Tim Seib had a drug problem, and I don't know Tim Seib personally, but my clients have reason to believe that's the case. That he was an employee of sort of a family company, that over the course of several years he became increasingly unable to perform his job due to his drug habits, that he would frequently make inappropriate, harassing phone calls to other company employees at all hours of the night, that he would call other employees in the middle of the night when he was drunk or intoxicated, that he would show up to company events under the influence, that sort of thing. So the reason why basically we want to image the cell phone, and why we believe it's relevant, is, first of all, it was originally issued to Tim Seib as a company phone. There is a open question. I know Mr. Goolsbee disagrees on this point, whether or not the phone is Mr. Seib's personal property, or whether it's owned by the company. For the purposes of this motion, I'm not sure that distinction is relevant necessarily. The rules refer to possession, custody, control. So sort of regardless of if it's a phone owned by the company still at this point, or whether it's a personal phone that's owned by Mr. Seib, the point is that it is in Mr. Seib's possession, custody, or control. I presume he has it with him, and is able to deliver it at any particular time to be imaged. So it is an electronic device that's in Mr. Seib's possession, custody, or control. We requested, through the ordinary course of discovery, a lot of different documents, communications, emails, that sort of thing, and attached to our motion as Exhibit B, you'll see communications between Scott Shanes and Mr. Goolsbee addressing some of the deficiencies in that production. The basis is there were text communications, other communications between Tim Seib and his three brothers, who are my clients. The only text messages that were produced in the ordinary course of discovery were between Tim Seib and my clients. So in other words, a text that my clients already had. So in other words, it's a non-production at all. It's things we already had. The text messages.
I don't see how any possible way you could say under In Re Weekly that imaging his entire phone would be appropriate. I do agree that
Agreed.
you're allowed discovery, but imaging the entire phone, I don't anticipate I would allow. And so
I agree with that, Your Honor. And we don't want to image the entire phone necessarily. We tried to narrow it in a significant way, both in terms of the date, in terms of the type of documents we were seeking. We also set forth we proposed a protocol by which anything that was imaged off of that cell phone would be provided first to Mr. Goolsby. Everything. We would see nothing at all until after Mr. Goolsby had the opportunity to review everything, to look through every document, every log, every piece of data that was on that cell phone that he could object, withhold, produce a privilege log, and then to the extent, what should happen is
what makes more sense to me would be, I guess there's certain employees that work for Seep Holdings that you're claiming that the issue is that he was making harassing text messages, I assume, and phone calls to certain employees. Is there any allegation that in the case involving anyone outside the company?
I don't think necessarily, but and you're part right, and there's a little bit more to it than that. Part of the sort of allegation is, if we're talking about wrongful termination, why was he terminated? Well, part of it is that he would go, and again, I don't know the man, I wasn't involved personally, but my clients have reason to believe that he would go missing for periods of time. So at a time that he was a company employee, he would be non-responsive. They wouldn't be able to get hold of him. He wouldn't be doing his job. So part of it is sort of the absence of evidence, right? The absence of, if he would receive phone calls, the failure to return them, or no emails that would go out over the course of several days, and that sort of thing. So it's sort of, part of it is, yes, Your Honor, what you're saying is inappropriate communications that he would send, but also part of it was the lack of business activity. This was a phone, whether it was his personally or company phone, the lack of him doing his job for several days at a time, which occurred.
So, Mr. Goolsby, my thought is that the minimum would be any type of communications with coworkers at the company would be produced. I'm not sure how to get to what Mr. Triano is requesting, which seems to be, I'm not exactly sure, maybe communications during work hours, or I'm not clear how you can figure out what you're trying to figure out based on looking at his phone. But
yes, Your Honor, I can address that. Look, first of all, he mentioned emails at one point. Well, the company email they have access to independently of the phone, and they've apparently produced a PST file of 2 years. So if they're saying there's a gap in emails, they've already got that. Here's the rub, Your Honor. We've asked them, why did you fire the guy? And they've said, well, wrongful termination is not an issue. They have failed so far to give us the company policies supposedly violated. What were the incidents where things happened that were bad? This is a fishing exercise, but Your Honor, we're supposed to talk to them later this week about any internal emails or text messages. I'm happy to take a look if there's coworkers that he supposedly talked to. Again, this is how regular requests for production, you identify a person during a time period about a subject matter. We were asking them, what have we been deficient on that? If they propound such discovery, we would look at it and go about it in the normal fashion. But doing a full imaging, as Your Honor has pointed out, that would be extraordinary. And I didn't hear how they meet in Ray Weekly Homes. He said he was going to address it, but I did not hear how they went through and solved those standards. The only thing I did hear was, well, we thought certain parts of text messages were missing. In Ray Weekly Homes says small inconsistencies like that aren't enough to get the full imaging of a phone. You have to have bad conduct, essentially.
I'm going to go ahead and deny the motion at this point. I think you need to go back and do exactly what Mr. Goolsby said, which is request specific conversations. You need to be specific in your requests and not try to do this kind of shotgun approach. You need to make a kind of more rifle shot.
Understood, Your Honor.
All right. Anything else today?
Nothing further, Your Honor.
Mr. Goolsby, do you have an order for me?
I have submitted one with our response, and I can email it to Ms. Penson if you'd like.
Let me see if I can take a look at it and if it's sufficient. Order deny motion to received. Okay, yeah, this looks fine. I'll go ahead and print that out. You don't need to get me a new one. So I appreciate it. You guys have a great day. Okay.
You too, Your Honor.
Thank you, Your Honor.
Thank you. All right, are both sides here in the Krapal case?
Yes, Your Honor.
Yes,
For my
Your Honor.
video.
So you heard about our issue with the court reporter. Are you guys okay with just using YouTube? And if you need a record, we can have the court reporter transcribe off of that, or do you want us to delay the hearing and reset it possibly?
Court reporter back, Judge.
Oh, she is?
Yes, Judge, I'm here, Judge.
Okay, never mind. Do y'all need a record?
I think so, yes. That's okay.
That's no problem.
And I'm ready, Judge, whenever you call the case.
We're about to call it. Let's go on the record on cause number DC 193038, Krapal versus Combs. Counsel, make your appearances.
Your Honor, my name is Maureen Farrell. I'm appearing on behalf of the plaintiff and counter defendant Diane Crapeau and Laura Renninger.
John Galini for the defendant and counter plaintiff Michael Combs Properties LLC.
Okay, let's go ahead and proceed.
Your Honor, we're here on two of my motions. I believe we can take them in the order that you would prefer. In time, it's our amended motion for discovery sanctions and our motion for leave to hear our motion for summary judgment.
Let's hear the discovery sanctions first.
Your Honor, it's pretty straightforward, although I confess that always filing too much paper as if you're going to spend hours and hours reading hundreds of pages of paper. But it's actually very simple. The court reserved judgment on attorney's fees when the motion to compel was granted by Your Honor on September 13th of 2020. And I'm merely following up on what is the right under the rules under Rules of Civil Procedure 215.1D that reasonable expenses in obtaining the order, including attorney's fees, should be recoverable when a motion to compel is granted, which Your Honor granted the motion to compel. And so I'm following.
So was there any additional bad conduct that occurred after my granting of the motion? Or are you just asking me to go back and award attorney's fees?
I wouldn't classify it as bad conduct. There was there was quite a bit of additional material that was supplemented well after the judge's deadline of September 15th,
Okay.
Including after our last trial date. Last night at kind of midnight, I filed a very short reply that gave just one example of these Flagstar mortgage statements. Those that were requested in April of 2019. There was initially 6 months produced. That was specifically requested and ordered in the motion to compel, right? They're then earlier this year in 2022, we get 4 more years and we're still missing 2014 and 2015. And so I wouldn't necessarily call it bad conduct, but it is absolutely conduct that has increased my client's costs. And that's why she sought the motion to compel in the first place, which the court granted, and it just carries on. So it's not really, we're not asking so much for punitive sanctions as much as compensatory sanctions under 215.1D to compensate her for the cost of having to chase these documents around. I'm happy to waive the request for an adverse jury inference. I know that those are very hard for the court to grant. And so I'll drop that and just ask the court to grant the compensatory attorney's fees of $15,565. We attached our invoices as well as our predecessor's invoices in an affidavit in Mr. Galini's response to our motion, which was fulsome. He didn't address whether those attorney's fees were reasonable or unreasonable, but rather focused on the substance. So I think, that typically you're entitled to attorney's fees and expenses when an order to compel is granted. And so I'd ask
Not in this court.
Okay, well, yeah.
I almost never grant those unless there's a pattern. So I'm not a big fan of awarding sanctions. So, but if I need to, I will. Mr. Galini, she says that you were late in complying with my order. Is that true?
Your Honor, it's not, and it is. And if you'd allow me the chance to at least reiterate what the order said, is it said and what happened is in Ms. Farrell's case, she was technically the third attorney involved. First, it was a Josh Carpenter, then it was a Logan Despain from the same firm. And then her firm and his firm were going to go together, and then they last minute separated. And she did get handed boxes of materials, and I believe with no information from her predecessors. Much of the discovery was there, but then how the order read, because Logan Despain and I, whenever we had our first hearing with you, it was determined that, and it was even stated in the order, in the event that defendants are in possession of additional responsive material or responsive documents previously requested by plaintiff's request for production, that defendants shall amend and or supplement the discovery responses of production within 15 days. And we made that deadline with everything that we had and were aware of. And then this is the biggest thing is, Your Honor, you gave us pretty much nearly a death sentence sanction anyway. It said basically that defendants are barred from producing at trial or any future hearing documents which were properly requested but not provided to plaintiffs in response to plaintiff's request for production by September 15th, 2020. Now, that was pretty much the death sentence. So that's a straight line.
How is that? That's not a death penalty.
Well, it is for us as far as being able to utilize anything that we later found. And Your Honor, this case stems from documents that they were requesting from 2004 all the way up. Now, the only thing that we're discussing here is things that were supplemented late. And there's very, very few documents. We re-supplemented documents in a better order after Ms. Farrell was brought on. But for one example, the Flagstar documents, I don't believe she'll be able to even tell this court how those were specifically requested. This is the defendant's personal mortgage. And I went back through this request for production again, and the interrogatory is just to be careful. We submitted those in an effort to help in finding a settlement of this case, not in abidance with any set of production. In matter of fact, we did submit after this deadline anything that we found that we felt like would assist this family in getting resolution to this, the allegations and the division of the assets that my client is still holding, just waiting for a division, as well as some that Ms. Crapo is holding. And so many of the documents that they say are late were actually never discoverable technically, but we gave in an effort to assist in settlement of the case. The Flagstar is an example of such. My client made a request to Flagstar, provided everything that he had, and then if we got anything later, we still had a duty, even if it was after September 15th of 2020, to still provide those fairly to the opposing counsel, which is what we did. But we're not talking about any great deal of documents. We filled
I guess, Ms. Farrell, let me ask this: what documents were ordered to be produced in this motion to compel that were produced late, that were subject to a request in the motion to compel?
I was actually just looking for the original motion to compel, if you bear with me for 1 second, because so the Flagstar documents are an example, right? I believe that those were.
But he says that those were never actually requested.
Well, he says that they weren't requested in the original request for production, which clearly predates me. They were requested under the general category of produce all documents financial records of Michael Combs that show where that could help us trace through where funds went.
So what I'm getting at, I guess, is that there were certain documents I ordered to be produced.
Yeah.
Were these part of the category of documents I ordered to be produced and they were produced late? Or because if he produces something late, but they weren't ordered to be produced, I don't definitely.
I agree with that. I agree with that.
Your Honor, I will say that the production reads that anything that was used or testing concerned the decedent, Betty Combs. And, you know, it never testing concerned, it never was any funds that had anything to do with it. And there's never been any evidence established that it ever would. This was a personal residence and a meager personal residence at that. And so we just wanted to try to paint the full picture as we tried to along the line to at least make every avenue. And Ms. Farrell's been congenial. We can only do what our clients will allow us to do on settlement. But I mean, we tried to provide and put together as many pieces of the puzzle, whether discoverable or not. And the order did not have a list. It said in the event that defendants are in possession of additional responsive documents. And Your Honor, we provided everything we were ever in possession of. Now, it was a lot of information for a lot of years. And there were I think maybe several missing months of bank accounts that had previously been turned over in discovery that he did find additional months of. And we did provide those, and those were late, Your Honor, but we also provided Quicken printouts and those things that would have substantiated those. But as he found them, whether late or not, we did make an attempt to provide. And there was never a list of documents, but it said in our possession. And we certainly did everything we can. And I'm not saying that it's not an excuse. I wish we would have had a binder with everything from 2004 to 2018, which is the genesis of the reason for the lawsuit. But we did not withhold anything. And if we found it, we tried to put it together and fill in the missing blanks beyond the discovery request.
So, Your Honor, the original motion to compel filed by my predecessor is Exhibit 2 to our.
Can you just share screen the order?
Oh, it wasn't the order. I can't actually. I wasn't referring to the order. I was referring to the motion to compel, which specifically has a list. Your order doesn't refer to the list. Let me see if I can share screen the order. Just a minute.
And while she's looking for that, I will respond to that. Is during the hearing, we determined that some of those things were requested and some of them weren't, but that Logan Despain and I were working through those to determine and try to get him answers to all of those, whether they had been requested or not, in a good faith effort to resolve this, which is the reason the order reads the way it does. And Ms. Farrell, you wouldn't have had privy to that information at the time, but that's why it was written the way it was.
Do you, Kit, do you have the order to hand?
I am looking for the actual order.
Yeah. It's Exhibit 1 to our motion, but I'm trying to pull it up.
I do.
I have it in paper.
It's yellowed, and I've just got the paper copy, but I'll see if I can hold it up close enough to the camera.
No, I don't want to do.
Yeah, and I'm just.
Guys, you should be able to share screen stuff at this point.
Yeah.
So it's attached to the actual motion to compel that was filed on 6/3.
It's attached to the what your order is attached. Yeah. It's attached to the motion for discovery sanctions filed. I'm looking at 8/21, but it was amended. And I will be able to pull it.
8/21.
8/30/2021. It's Exhibit 1 to that. And Exhibit 2 is the original motion to compel.
And Your Honor, it was signed by you on September 13th of 2020.
September 13th of 2020.
Was the actual signature date, Your Honor. But it does not say we failed to produce any documents whatsoever, because that wasn't the case.
No, because Your Honor wouldn't be in a position to tell the defendants what documents they haven't produced. The plaintiffs are not in a position to tell the defendants what documents they haven't produced. The admonition that documents that have not been produced may not be used by the defendants at trial is cold comfort, when what we are asking for, the documents we're searching for, are the documents that show how the money that Betty Combs gave to her son and then got moved through a series of bank accounts over a period of time, where that money went, right? It generates from Betty, it gets moved into multiple accounts, and then it goes into a spider web of different accounts. Flagstar, for example, is one of the accounts where money may have been transferred into through a series of transactions, which are incredibly difficult to trace. And
Your
so
Honor,
we're not
the
talking
mayhem
about
is the whole issue here.
Excuse me, Mr. Galini. We're not talking about documents. We're not talking about documents that we know that they have, or there are documents they should have. If you can produce a Flagstar mortgage statement,
So is this the order we're talking about?
this is your order. And
Okay.
then the motion to compel has a list of documents in it. The motion to compel that precedes the order.
Okay, let me. Okay, so that is, it just says that any documents requested by the request for production. Okay, so now I need to go, I guess, back to the request for production itself.
Do you just need to look at the motion, the motion to compel, and see what documents were highlighted in the motion to compel?
But you'd have to go back to the production, because just because you make a list of things does not make it a legitimate list. Which was my whole argument in the first place.
Why would the court grant, and why would you agree to an order compelling documents that in response to a motion to compel?
Can you share screen the motion? I agree with Mr. Galini on this. I need to see the request for production that you say that he untimely responded to.
No, that's not what I'm saying. What I'm saying is that the court granted a motion to compel,
Right.
and then there were responsive documents produced well after that. And that when a court grants the motion to compel, there is at least an option for the court to grant some fees. So wait, you would like to see the original request for production from 2019?
So as I understand the issue, the request for production, I ordered those to be responded to. He had a certain period of time. You say that there's additional documents that were responsive to that particular request for production that were not produced late. That's what I'm trying to get at, is what documents that were requested in the request for production that were ordered to be produced were produced after the deadline.
Well, okay. So do you want to see a request for production from 2019, or do you want to see the motion to compel, which was granted, which had a list of documents in it?
I don't know why that's relevant.
Because, well, I mean, it's relevant if you say it's relevant, because the order compelling discovery was granted in response to that motion, which referred to specific documents.
There has to be a request for production that orders the requested documents.
Well, then that's why the court granted the motion to compel in the first place. But if we want to go back and I feel like we're trying to re-argue the order.
No, I'm just trying to figure out what documents we're talking about.
Okay.
Are there
Let me share my screen. Hang on.
Okay.
Well, Your Honor, I think we are trying to talk about the order. It was written in a certain way for a reason. And that's why you specifically had us incorporate the word "in the event." And, it wasn't, because we had already responded to the discovery. We just were still looking for some items and readily advised this court as well as opposing counsel of that. And we got everything that we possibly could in. And like I said, whether it was discoverable or not, and we still continued to amend well beyond what was discoverable to try to satisfy an insatiable appetite for documents, whether they're admissible or not. And we'll continue to do that. We've really tried to do that.
Okay, Your Honor, you're seeing the original motion to motion to compel filed by my predecessor.
Okay.
Okay, Mr. Galini, do you have the 2019 RFPs to hand in case the court wants to trace those back? This is the list of documents, A through P, specifically referred to in the request or in the motion to compel.
And actually, it's going to be exhibit, and I'm not in my office, so I'm in a conference room, so I don't have access to my computer, but it's exhibit A to defendant's response to plaintiff's amended motion for discovery sanctions.
So that's your response. It's exhibit A to your response.
Correct.
Okay.
It's our responses, but it has every request for production listed.
Okay. So after we look at this, if Your Honor wants to see the original request for production, I will pull that up as well.
So
But
these are the documents you said that were ordered to be produced.
Correct. Subject to that September 13th order. Now the court doesn't specifically refer to these documents because it was granting this motion. So now in retrospect, Mr.
Right.
Galini is saying that these documents didn't fall within the RFP in the first place. Well, the time to argue that really was when the court granted the motion to compel. There is no doubt that, and I gave the example of this Flagstar account. Your Honor, if you are able to get 2011, 2012, 2013, and 2016, you can produce 2014 and 2015. We still don't have 2014 and 15. That's an example. In my reply, you'll see why we care about that. There were $35,000 in payments to that account, from that account in February 2015. The arduous process of trying to figure out where money ended up is, Mr. Galini refers to looking for the smoking gun. We're just trying to figure out where Ms. Combs' money went, right? That is an example. Now, Mr. Galini and his client have produced responsive documents. I don't doubt that Mr. Galini is absolutely trying to get all the documents, but there are specific years, specific time periods where documents have been produced both before and after, but not for those specific periods. Even this hearing itself, the motion to compel, the original motion to compel that my predecessor did, all of that costs money. And so when the court grants a motion to compel, and we're still getting documents after the trial date that was set back in September, there's a cost to that. And I don't think it should be borne by my clients.
And those are not they were ordered documents. They were ordered, meaning put in a better order. It's not additional documents after the trial date. They were supplemented prior to the trial date, and once again, put in a better order and dates ordered. Your Honor, additionally, she's using just an example that's not even part of the discovery. And secondarily, I will advise the court that they've got his personal bank records as well to show the payments that were made for the missing year. Mr. Combs went through his personal records, also contacted Flagstar, even though we didn't have a duty to do so, at least is our position. And those were all of the years we could ever get. We can't get documents that he does not have.
Well, we subpoenaed them. We subpoenaed them last week, those 2 missing years in the middle of the range. And hopefully we'll be able to get them from Flagstar.
I hope
the Berkshire Hathaway counts, Your Honor, referred to specifically in the motion to compel. We don't have any of those, right? Thousands and thousands of dollars went to Berkshire Hathaway from Mr. Combs' accounts, but Mr. Combs' accounts were in part funded by Betty Combs' accounts. That's why we care about this. It's not because we want to dig through somebody's personal banking records. It's because money originates with mom. It goes into a variety of accounts and then goes out.
Your Honor, she's trying to practice her argument for the jury. Your Honor, these things have been produced if my client had them or could obtain them, and none of these items have been withheld whatsoever. And some of these accounts that they've asked about, there's emails that will show, and some of them were included.
Why were these flags? I guess my question is, why were these Flagstar accounts produced late?
Your Honor, they weren't produced late. First of all, we produced anything that we had, and if we got anything later, we still produced it. And once again, the Flagstar accounts were never even part of the production. Just like the Berkshire Hathaway, and I'd have to go through a slew of emails, but every one of these documents were discussed whether they were under production or not, to let them know whether my client was aware of these accounts. Also, Betty
Okay, so
Combs-
this is the last thing I'm going to hear on it. Mr. Farrell, I want you to show me the request for production that requests the Flagstar the accounts.
Where the RFPs would include the Flagstar accounts?
That requested the Flagstar accounts.
Well, when you sent out the first RFP in 2019, Your Honor, they didn't know.
Can I just see that? Okay, Ms. Farrell,
Okay.
can I just see there are the RFP that requests the Flagstar bank accounts?
It didn't request. It would not have requested them by name because at that time they didn't know that those existed. Right? They don't know that.
Then the request that would have required the Flagstar request.
Okay. Yes, sir. Yes, Your Honor. So I am looking for Mr. Galini's response. Are you watching me like toggle through my screen?
No, we can't
Okay.
do it.
Okay.
We're looking the other direction, Maureen.
No,
Yeah,
no, it's not. You're not
Just
share
it.
screened. You'd have to share screen it.
I'm just
Okay.
glad you're doing it because I'm in the opposite room, so I don't have access to put it on.
I'm doing my best.
Yeah, I'll represent. I've gone through it and I have not seen it after going through it several times. But like I said, the issue is we provided even though we didn't even have a duty, we provided everything.
I
that we
just am
had
asking
or
for
could
one
obtain.
thing. That's what I want to see.
Okay, hang on. Okay, what I have the maximum number of files in Adobe on my,
It was Exhibit A to my response filed on 5/9/22.
okay. Okay, I've got that. All right, Exhibit A. Exhibit A is your response to the first request for production. Okay, I've got it. Share screen.
That will give you the wording on the production. That's all. And if there's a typo, excuse the typo.
Okay, so this is defendant's response to the first
I just want to know
RFP.
which request you're saying would require that to be produced.
Well, number one, documents signed, delivered by Betty Combs relating to the holding, transfer, disposition of property belonging to Betty Combs.
Okay, is that responsive, Mr. Galini? Were those documents responsive to that?
Your Honor, this is his personal mortgage. How does this relate to Betty Combs?
Relates to the holding, transfer, and disposition of her property, which is why then it's specifically listed in the motion to compel. The RFPs are broad. The motion to compel was specific and narrow. Court grants the motion to compel. You're not going to see the word Flagstar in here because we didn't know that existed.
Your
So,
Honor,
for
you do
example,
know there's communications back and forth with counsel. Even Exhibit C to
No,
our
no,
response
wait.
states Flagstar, this is my client's mortgage lender.
Like after this original RFP, this is the first document, the RFPs. So
Correct.
for
And-
example, communications, notes, deeds, other documents written or signed by Betty Combs relating to holding, transfer, or disposition of Betty Combs's money. This is disposition of Betty Combs's money.
So you're
Find
saying
out-
that the Flagstar mortgage payments are related to the disposition of her money? That's your essential argument. And
They
it
may
should
be,
have been
yes.
produced.
They may be
So,
yes, because we have to trace through her money through a series of accounts. I mean, I
Your
wish.
Honor, my client's also a
we wouldn't be
doctor and
litigating
makes
it.
a living.
Of course. But that's why my predecessor asked for a motion to compel where the Berkshire Hathaway, Flagstar, other accounts were specifically requested because in the process of discovery, these are responsive documents that may tend to show the disposition of Betty Combs's property.
And Your Honor, I don't know how much time you want to spend on this, but my exhibit C to my response is the communication where all of these, the list that they provided of things they thought we may or may not know about or have responsive documents to, we communicated back to Josh Carpenter, the attorney, and went through every account and stated whether we have knowledge of that or whether we not, or whether it's related or not. And so every one of these things that were not part of a discovery request specifically in an attempt to clarify, we went back through every one of these things. And the response was, this is my client's mortgage lender for his home, had nothing relating to Betty. As far as Berkshire Hathaway, number 5, this account is unknown to my client. And so, just because they're showing something come up somewhere on the internet or wherever.
Wait. That cannot be true. And if it was true, then I think the time to argue about that would have been in 2020 when the court granted the original motion to compel. The Berkshire Hathaway
We
account
actually had
are-
these conversations, and that's the reason the order says in the event that defendants are in possession of additional responses, that we're to produce them, and we did.
Your Honor, do you want to hear continuous talking about this?
I guess my thought on this is that I very rarely award sanctions anywhere. If there was a pattern of abuse, I understand, I think where you're coming from, Ms. Farrell, which is there were documents that in a broad sense were requested that you were eventually able to identify and then he eventually produced. Let me finish. And so I don't see anything out of the norm on how discovery is conducted that I see. I do this all the time. I understand what Mr. Gleaney has done. If there'd been a situation where you had specifically requested a request for production and said, hey, we are, we need the Flagstar mortgage accounts from 2015 and 2014, and that was part of the original request for production, and then that was ordered to be produced, and then he didn't produce it, I might award sanctions in that case. I'm not going to award sanctions in this case. All right, guys, thank you so much.
Oh, hang on. We have a second motion.
Okay, go ahead.
Which will be very brief. Your Honor, I filed a motion for summary judgment on Mr. Combs's counterclaims against Diane Crapeau. I filed that motion. It was a no evidence in traditional MSJ on Mr. Combs's counterclaims against my client. I filed those on the 22nd of May, 2022. That was 2 days after we took the deposition of Mr. Combs on his affirmative claims against my client. When I filed the motion.
This may be moot.
Okay.
Remind me again, have you guys agreed to the visiting judge that's going to be there on 6/28?
We did,
Yes.
Your Honor.
You did agree, okay.
Yes. And what I just wanted the motion for summary judgment to be for the court to have a hearing on it prior to the trial. And then when I drafted it, went to set it, we discovered your policies and procedures that say that dispositive motions have to be heard within 30 days of trial.
More than 30 days from trial.
Which was never going to be possible because the court only granted the request for discovery for Mr. Combs's deposition on his affirmative claims against my client after the hearing on, I guess, March.
How would you propose at this point? I'm not necessarily opposed to hearing it. It's just when.
Oh, so I filed it on the 22nd of May, right after his deposition. So Mr. Galiti, Mr. Combs have had notice of it now for 21 days today. Anytime that the court, I would.
But you need to provide 21 days notice, right?
It's 21 days. Well, what the rules say is 21 days from the filing of the motion. I haven't been able to set this hearing because the court wouldn't allow me to set the hearing, Your Honor. Like I had to have this motion for leave to set the hearing.
But you have to. Okay, I disagree with your interpretation. I think it's 21 days. The hearing has to be set at least 21. You have to give 21 days notice of the hearing date.
That's not what 166A says, respectfully. And I couldn't. I tried to, and the court would not allow me to set the hearing. I tried to set it immediately. And then the court said no, because of the 68th policies and procedures, you're not allowed to set it.
Mr. Galini?
Yes, Your Honor. As far as if you'd like, I will basically refer to our response on this. Basically, we filed our counterclaim 9 months ago. Also, there was a motion to strike that the counsel for Crapo didn't set for hearing, and it was not heard until March. March is whenever the court issued an order allowing them to, for the limited purpose of taking the deposition of Michael.
I just want to point out, because 166AC says the motion and any sworn affidavit shall be filed and served at least 21 days before the time specified for the hearing.
And it would be if the court says that the hearing is going to be in 2 weeks, right? Like just before the trial, absolutely. The motion and affidavits were filed and served 21 days before the date specified for the hearing. I filed it on the 22nd of May. That's my point.
I've never heard anyone interpret it the same way you are, but I guess the bottom line, Mr. Galini, is there's a couple ways we could deal with this. One is you could agree to have this heard. I'm not necessarily opposed to having it heard. I only have one date that I think I could do it, but you would have to agree to less than 21 days notice.
I'm not going to, Your Honor. This is part of trial. We're 2 weeks out from a jury trial that we've been preparing for, and this counterclaim is part of it. It was filed long ago. It was filed in time to do it. It was defendants. It was Crapo's own choice to not have the deposition until May, I believe it's the 20th, and then to shoot over the weekend. That's on a Friday, and to shoot her motion for summary judgment on a Sunday, and with no motion for leave or anything. And
I did file a motion for leave. That's why we're here.
And Your Honor, the other reason on this is if you'll just take a look at her motion for leave, I don't believe she probably drafted. I think she had some help in her office doing it and didn't get a chance to look at it. But it is replete with failures to mislead the court. And Your Honor, that you can't be rewarded with a hearing on something of that nature. And of course, just by the nature.
When was the pleading on this counterclaim? When was it first pled?
August 31st of 2021, before the trial date of September 7th.
All right.
Right.
And the motion for leave is denied.
Okay.
Anything? Can you get me an order on that?
I've got an order filed, Your Honor.
Let me look it up. I see it. All right, I'll go ahead and sign that.
Thank you, Your Honor.
Thank you, guys. Good luck with Judge Wheelis.
And I guess good luck on your vacation.
Yeah.
You're going to have more fun than we will.
I hope so. I hope that's true.
May we be
All right.
dismissed?
You are dismissed.
Thank you.
Are both sides here on the Hedden case?
The judgment creditor is here.
I think I saw Mr. Hedden sign on.
Yes, sir, Judge, I am here.
Okay, let's go ahead and go on the record on this. So on the record on DC 1815576, Hedden v. Abundant Life, counsel and parties make your appearances.
Catherine Nelson for judgment creditor Abundant Life Therapeutic Services Texas LLC.
Thomas Hedden, pro se plaintiff.
All right. I understand that we're here on a motion to request attorney's fees or a motion on the attorney's fees. Is that correct?
Your Honor, that is correct. In part, we are here on a motion to compel post-judgment discovery in which we have requested attorney's fees. Briefly, we served post-judgment discovery on April 4th. The responses were due on May 5th. No response was filed. We filed our motion to compel. Mr. Hedden responded, and after we filed our reply on June 8th, finally, and in fact, yesterday, 6 weeks after they were due, Mr. Hedden finally filed what he called were responses. May I share my screen?
Yeah, go ahead.
So, and again, I'm not going to take too long. This is the response, one of the responses initially. Because the responses were late, all objections have been waived. There apparently are bank accounts on which Mr. Hedden is authorized to sign on for at least 2 different entities. He admits they exist and he has refused to provide them. All of these objections have been waived.
So he says that there are accounts provided in a link. What is that? Are there accounts all provided in the link? Have you looked at the link?
Yes, Your Honor. They are for Mr. Hedden, and it appears his wife, and an entity called Head and Heart Community Builders, Inc., but not for the 2 entities listed here, for which Mr. Hedden has asserted apparent privileges, but those privileges were waived because the responses were filed, or this document was only filed yesterday, 6 weeks late, and the interrogatories also were not verified.
And have I already overruled all the objections at this point, or?
Well, we're asking you to today, sir.
Okay. Mr. Hedden.
Yes, Judge. I had a complete mistake of the law. I thought when I appealed that there was an automatic stay, and I did apologize to the defendants. I apologize to the court that we're even here for this. If I had the correct understanding, I would have provided the discovery and would have had the opportunity to maintain my objections. My objections is really one, but in part 2, I'm objecting to providing the information from my law firm, specifically my clients. And one of my clients is the church that I attend, my grandfather's church. Those items would normally not be discoverable. I understand that under the rules I've waived them, but I also understand under the rules that the court does not have to compel that discovery. I'm simply trying to preserve the attorney-client privilege of the few clients that I have, which includes the church. So my objection is simply not to divulge the protected information of my law firm. In terms of any other discovery that they want, I don't fight them. I have no other objections. Everything that they've asked for, other than that, I'm trying to provide. I just, for obvious reasons, don't want to provide information that would break attorney-client privilege.
Your Honor, may I?
Yes.
This is not this is not trial discovery. This is post-judgment discovery. If he has any assets, we're entitled to discover them. And unfortunately, this is a continuing pattern of Mr. Hedden's. He's disregarded the rules until he is compelled to comply with him by Your Honor. This is gamesmanship. Mr. Hedden is a licensed attorney. We're entitled to discover his assets in post-judgment discovery.
I'm more than willing to provide them any of my assets, Judge. And in fact, I already have done so. When they filed their motion to compel, I immediately emailed the defendants and told them I apologize for my misunderstanding of the rules and asked if we could come to an agreement for me to provide all of my assets and all of the discovery of what I own, which is hardly anything. And just so that I could keep my law firm clients and my church confidential. Now, what they're asking for and what I'm asking for are not incompatible, Judge. I'm just trying to keep that confidential for obvious reasons.
So, Ms. Nelson,
but in terms of my assets,
well, what exactly are you trying to get from his law firm? I mean, any communications he's had with his clients, I don't see how that would be at all relevant to even post-judgment discovery. Any assets of the law firm, I could see how that could be in terms of accounts and things like that. And so what exactly are you trying to get?
We are trying to get the accounts for his law firm. We're not asking for any communications. We're asking for what the assets of his law firm are. He hasn't identified anything responsive that is actually privileged. What he's identified is that he doesn't want to provide any information regarding the assets held by his law firm. We haven't asked for anything privileged. And as Your Honor just said, you know, to the extent that his law firm holds assets, we are entitled to discover them.
Okay, does that alleviate your concern, Mr. Hedden?
well, Judge, if I could, the problem is that my bank accounts have my clients' names on the payments that they made because they've made payments to my firm electronically. It's not that many clients. It's not that much, but their names are on the bank accounts. And I am concerned that providing the bank accounts would disclose their names, would disclose my clients. So if I could provide that in a redacted form, I'd be happy to do that. But with regard to the church that I am a trustee on and a minister at, that church has no assets of mine whatsoever. So even though I am a signatory on that account, there's nothing discoverable there that could be used to satisfy a judgment. So I have no problem if the court would allow me to provide redacted copies of my law firm's accounts. But with regard to my church, I'm not on staff. So nothing that the church owns or has could be used to satisfy the judgment.
Your Honor, I'm sorry.
My apologies. I was just saying that outside of that, we have about 15 members. Most of them are 65 or older. There's not really anything there that they have. And I understand that I waived my objection, but I would simply ask the court.
You gotta, I don't know. I understand where you're coming from. It would be a lot easier if you had done this correctly. We wouldn't, you're putting the court in a difficult spot here, but I don't want the church, information to be disclosed. And you can provide redacted statements in terms of the redaction would be redacting out the client's names, but everything else needs to be produced. Ms. Nelson would be in order on that. And is there any way